Good evening, guys. I am Raven Kyle Escobalida, and I am here to present to you uh, the topic that is all about under the subject criminal procedure and court testimony. Specifically, the Rule 120, also known as the judgment. So, I will read to you my notes about this certain topic about judgment. According to this rule, Rule 120 of Criminal Procedure and Court Testimony, the judgment, Section 1, Judgment, definition, and form. Judgment is the adjudication by the court that the accused is guilty or not guilty of the offense, charge, and the imposition on him of the proper penalty and civil liability, if any. It must be written in the official language, personally and directly prepared by the judge and signed by him, and shall contain clearly and distinctly a statement of the facts and the law upon which it is based. So the second section of the judgment of the Rule 120. Section 2. Contents of judgment. If the judgment is conviction, it shall state that number 1, the legal qualification of the offense constituted by the acts committed by the accused and the aggravating or mitigating circumstances which attend its commission. Number 2, the participation of the accused in the offense, whether is principal, accomplice, or accessory after the fact. Number 3, the penalty imposed upon the accused. And number 4, the civil liability of damages caused by his wrongful act or omission to be recovered from the accused by the offended party, if there is any, unless the enforcement of the civil liability by a separate civil action has been reserved or waived. In case the judgment is of acquittal, it shall state whether the evidence of the prosecution absolutely failed to prove the guilt of the accused or merely failed to prove his guilt beyond reasonable doubt. In either case, the judgment shall determine if the act or omission from which the civil liability might arise did not exist. The third section, Section 3, Judgment for two or more offenses. When two or more offenses are charged in a single complaint or information but the accused fails to object to it before trial, the court may convict him of as many offenses as are charged and proved, and impose on him the penalty for each offense, setting out separately the findings of fact and law in each offenses. Section 4. Section 4 is entitled Judgment in Case of Variance Between Allegation and Proof, wherein, when there is a variance between the offense charged in the complaint or information and that proved, the offense as charged is included in or necessarily includes the offense proved. The accused shall be convicted of the offense proved which is included in the offense charged, or of the offense charged which is included in the offense proved. The fifth section. Section 5, which is the when an offense includes or is included in another. An offense charge necessarily includes the offense proved when some of the essential elements or ingredients of the former, as alleged in the complaint or information, constitute the latter, and an offense charge is necessarily included in the offense proved when the essential ingredients of the former constitute or form a part of those constituting the latter. The sixth section, Promulgation of Judgment. So, in promulgation of judgment, the judgment is promulgated, which is reading it in the presence of the accused and any judge of the court in which it was rendered. However, if the conviction is for a light offense, the judgment may be pronounced in the presence of his counsel or representative. When the judge is absent or outside of the province or city, the judgment may be promulgated by the clerk of court. If the accused is confined or detained in another province or city, The judgment may be promulgated by the executive judge of the regional trial court, having jurisdiction over the place of the confinement or detention, upon request of the court which rendered the judgment. The court promulgating the judgment shall have authority to accept the notice of appeal and to approve the bail bond pending appeal, provided that if the decision of the trial court convicting the accused shall change the nature of the offense from the non-bailable to bailable, the application for bail can only be filed and resolved by the appellate court. The proper clerk of court shall give notice to the accused personally or through his bondsman or warden and counsel, requiring him to be present at the promulgation of the decision. If the accused tried to in absentia because he jumped bail or escaped from prison, the notice to him shall be served at his last known address. In case the accused fails to appear at the scheduled date of the promulgation judgment despite notice, the promulgation shall be made by the recording judgment and the criminal docket, and serving him a copy thereof at his last known address or through his counsel. If the judgment is for conviction and failure of the accused to appear was without justifiable cause, he shall lose the remedies available in these rules against the judgment, and the court shall order his arrest within 15 days from promulgation of judgment. However, the accused may surrender and file a motion for leave of court to avail of these remedies. He shall state the reasons for his absence at the scheduled promulgation, and if proves that his absence was for justifiable cause, he shall be allowed to avail said remedies within 15 days from notice. So the last section. The section 7, is titled Modification of Judgment. In modification of judgment, it means a judgment of conviction may, upon motion of the accused, be modified or set aside before it become final or before appeal is perfected. Except where the death penalty is imposed, a judgment becomes final after the lapse of period for perfecting an appeal, or when the sentence has been partially or totally satisfied or served, or when the accused has waived in writing his right to appeal, or has applied for probation. So that is all about the Rule 120 of the Criminal Procedure and Court Testimony, entitled as the Judgment or Promulgation of Sentences. Thank you.